Sorry, my fingers weren't working too good.
That's for you. I'll trade.
Before they leave, there are evaluations on the
Oh,
counter
okay.
back there.
You'd like want us to pass those out too?
No, you don't have to pass them out, but if anybody as they're leaving can fill them out.
Perfect. Thanks, Lee.
So anything else, bathrooms are through there.
I
so
know
that-
that. Okay. Thank you.
Anything
I
else
appreciate
you
it.
need from me?
Nope, I'm good. I think if my parking runs out, what do I do? Go back there and plug in my.
What are we doing here?
I'm okay. I got 2 hours from now, so it's 8
Nice person. Thank you.
Why don't you write it down and I'll put it.
You want to get this for the night? Here. You have something?
Yes.
Okay, that's nice. One of the things we have.
So it's Burger King. Burger. Hello, everyone. Good evening. My name is Owen Egan. I just want to make sure Jen is all set and everybody here in the library is
We're
set.
going to start in a few minutes.
In a few minutes? Okay. So just bear with us a second. Thank you. Just want to make sure everybody got a handout. There was 2. There's one that's kind of colored.
There's two?
There's 2. Just 2, right. Exactly.
Okay.
We'll put this.
Want me to let you go in this one?
Sure.
Ah.
I ask you a question that's not personal, but not public either.
I just want to make sure I'm aware of what my cue is.
couldn't get access to.
Good. Hello, everyone. My name is Owen Egan, and I'm the West Hartford Probate Judge. Welcome to the four-part series on understanding probate. I really appreciate that everyone's here. This was formerly called Demystifying Probate and Estate Planning. That was a few years ago, so I don't know if any of you attended that series, but that was an excellent series as well. We have a great panel here tonight for you. And we have a great panel in the future sessions. And there's going to be, as I said, 4 sessions. The first is the probate process. The second is the estate planning basics. Next is estate taxation and trust. And then the next is conservatorships and Title 19. And we'll have 2 to 3 attorneys at each of those sessions, and they will kindly give us information. They're all experts in their field, and by my calculation, I think they've all given a total of about $100,000 of their time to come here to West Hartford and to share their knowledge with you. So I'm very happy that they were willing to do that, and I'm excited about this program. I have a lot of fun at this program. The first here is the probate process, and the 3 panelists who I will introduce individually in the future are immediately to my left: Kelly Ambrosio, Maryanne Sharon, and Neville. All are 3 very accomplished attorneys in their field of probate, and all are here to share their knowledge regarding the probate process. So as I said, I'll introduce them, each of them individually in a minute. The history, a little bit of history about the probate court. The probate court was established in this state over 300 years ago. It was probably the first court of this state. Back then, they had 4 jurisdictions. They had Fairfield, New London, Hartford, and New Haven. And they dealt with basically two different areas of law. They dealt with the disposition of assets, the transfer of assets upon death, and they dealt with guardianships, individuals who needed a guardian. The disposition of assets would have been dealt with by a will or by law, how to transfer assets when someone dies. The colonists had to start some type of program where they would transfer that property, and that was done over 300 years ago. There are 54 probate courts now in the state of Connecticut. At one time there were more. They've reduced it to 54 probate courts. They're all regional courts. Our region happens to be just West Hartford. And as I said, I'm the judge in West Hartford, so we're lucky enough to have just West Hartford as our region. Some of the judges have several towns as part of their region, and they represent several towns. Our probate court in West Hartford was established in 1982. We broke away from Hartford. John Berman was the first probate judge here in 1982. He served for a number of years. After that, Sidney Elkins served, and then I'm the 3rd probate judge in West Hartford. The judges serve, and their jurisdiction is under the authority of the state of Connecticut. So the state legislature determines what our authority is. Back then, we had those 2 areas, as I said, guardianships and the disposition of assets at death. Now there are several areas that the legislature has assigned to the probate courts. They would include decedents' estates, trusts, conservatorships, still guardianships, adoptions, my favorite, because it's actually a happy time in the court. There's a lot of sad things that happen in the probate area, and the adoptions are wonderful. They also deal with removal of parents as guardians, paternity matters, emancipation of minors, commitment hearings. We have a psychiatric hospital here in West Hartford. I don't know if you know that. It's where the old Hebrew Home campus was. It's the Connecticut Behavioral Health Center here in West Hartford, and it's right by the Jewish Community Center. It is still affiliated with the Hebrew Hospital, and yet they share space in their building. We deal with also name changes, and then commitments and treatments for people with drug and alcohol issues. In summary, the court deals with death and its consequences, capacity, people who may not have capacity, and parenting. So those are the three areas that we deal with primarily. The service, our job in West Hartford, in the West Hartford Probate Court, is to provide service to anybody who comes to our court. And our clerks do the same thing. They're service-oriented, they're kind, compassionate, and they're very knowledgeable. We have 3 clerks in our court who have over 30 years of experience. Actually, Lori Rica, who is the lead clerk, has over 35 years of legal experience, and she has been with all 3 judges, Marlene Karp, James Felice, and there are others. We have a total of 7 clerks. They're all very knowledgeable, they're all very helpful. If you haven't been to the probate court, it's right over in the town hall. It's on the 3rd floor. You're welcome to visit. The court is conducted in the council chambers, which is right across from the clerk's office. And as a judge, my job is to be fair and impartial, and I try and also be compassionate and kind to all those who come to the court. It's a little less formal than Superior Court or in the Federal District Court, but there are some formalities. We do take testimony. We do have people file motions and so forth, but it is a people's court, and if you don't understand the process, we help you with the process. We can't give you legal advice. That's what these great attorneys are here for. We can help you with the process, and that can be very, very beneficial if you find yourself as a fiduciary of an estate or a guardian, etc. So any information that you might want to find out about handling paternity matters, handling a decedent's estate, handling a commitment, handling a conservatorship, for instance, that can be found either online or you can go to the probate court, and we have pamphlets that give you a summary of what your duties and responsibilities are, say as a conservator or a person who is a fiduciary of an estate. A fiduciary is the executor of an estate, someone who's in charge of the estate and the estate process when a loved one dies. So please, please come into the court, meet our staff, ask questions. You're not going to be disappointed. You'll be very happy, and you'll be met with kind and friendly faces. And I hope you find that to be the same in the court itself. The handouts that you've received tonight, one of those are one of the pamphlets that we hand out in court, so that's helpful. Take a look at it. You may develop some questions tonight. We're going to allow you to ask questions after all the lawyers have spoken. So we're not going to take questions after each lawyer speaks. We're going to let you start with questions after all 3 lawyers have spoken tonight. So please hold your questions, write them down, and then you can ask them at the appropriate time. The other handout was a handout that will be used and referred to tonight by the lawyers here. It was they helped us develop that so that they could give you examples and help you understand the probate process. So, without further ado, let me introduce our guest speakers. I'll start with Attorney Sharon. Maryanne Sharon is a West Hartford resident, and she's here seated in the middle, and she has over 39 years of legal experience.
She looks so young.
She is. She does. I agree. She has, as I said, 39 years of legal experience. Maryanne is the founding partner in her firm known as Charter Oak Law Group, located in Bloomfield, Connecticut. She is an experienced trial lawyer and trust and estate lawyer. Maryanne's practice areas include estate planning, including special needs planning for people who have special needs, probate administration, probate litigation, elder law, real estate, and small business planning. Donald Neville, who is seated over at the end in the blue jacket. Don is a resident of West Hartford as well, and his law office is located in West Hartford as well. He has over 23 years legal experience. Did I get that right? 23 years legal experience. Don is an accomplished trial lawyer trying cases in all the courts in this state, including the probate courts, there's 54 of them. I don't know if he's tried in 54 courts, but he's tried in many of them. the Superior Court and in the Federal District Court. He also does appeals as well, and I believe Maryanne does appeals as well. His specialties include representing creditors, beneficiaries, and fiduciaries in contested probate matters. Don has tried countless cases in all of these courts, some involving will contests, conservator issues, issues concerning powers of attorney, and I think you'll hear a little bit more about that tonight. Kelly, finally we have Kelly. Kelly is a resident of Hartford. She's licensed to practice in 2 states. She's licensed to practice here in Connecticut, and she's also licensed to practice in Massachusetts, which can come in handy. Kelly has offices in both West Hartford and in West Springfield, Massachusetts. And she specializes and focuses on estate planning, probate matters, and real estate matters in both states. And she has appeared in both probate courts in Massachusetts and the probate courts in the state of Connecticut. So she's also a very accomplished attorney, and you'll hear from her as well. So I really appreciate that they're all here tonight volunteering their time, and you have a very good program set out for you tonight, so I think you'll enjoy it. But I think we were going to begin with Maryanne, is that correct? Oh, we're going to begin with Kelly. All right. So Kelly, I'll let you take the podium. Here you go.
Oh, stand up.
Yeah.
Okay. All right. Can everyone hear me?
Yes.
All right, great. So welcome. Thank you all for coming. I am going to start, I'm going to be referencing this handout. I did not make it. One of our colleagues over here did. I won't name any names. It's very handy, and it's a very common scenario I find, this family structure, the relations in it. So I really liked this example, as well as the list of family assets that are here. So I'll be referring to this. But to start, so the purpose of what I'm going to be talking about is what happens to a person's assets when they pass away, right? And that's the whole point of really what probate is in a nutshell, is what happens when an individual passes away, what happens to their affairs, to their assets that are left behind. A very common misconception that people often think, and a common question that I get is, well, can't everything just go to my family? They'll know what I want, and I already kind of have things in order. And while that's a nice thought, and that would be very easy, that's unfortunately not how it works. So the best way to accomplish your goals and to have your assets pass as you would like them to is to have a will in place, specifically outlining how you would like your assets to pass and how they would transfer. And if you do not have a will, then they will pass in accordance with Connecticut statute or Connecticut law. And in a sense, the state therefore dictates how your assets will be passed. And I won't get into all the details of that because it really varies based upon the individual. And so another common misunderstanding that people have is that if they have a will, then when they pass away, their family can just pick up the will and start distributing assets in accordance with it. And that is wrong. That's not accurate. While the will does take effect, quote unquote, upon death, it really depends on how the assets are owned and what the will says, and I'll talk about that in a couple minutes. Another common misconception about the will is that whoever is named as executor in the will can just assume that authority immediately when the person passes away. So for example, I've had individuals come to me and say, oh, I'm named as executor in my mom's will, so I'm going to start listing her house because I want to sell that as an asset. Or they might take the will and just go immediately to the bank and think that they can liquidate those assets or have access to the bank account. When there's a will and it names an executor, you have to present that will to the probate court, and a judge has to formally appoint you as executor. And until you have that certificate formally appointing you, that authority does not take effect. And so a will names, like I said, an executor, and that's another name for an individual that's appointed to handle your affairs, wrap up your wishes, or administer your assets in your will. And if there is no will, then that person is called an administrator of the estate. And similar to excuse me, the probate court appointing an executor, the probate court will appoint an administrator. They both have a fiduciary duty to act either in accordance with the will or act in following Connecticut statute and to do right by the decedent. So I know that's very broad and that's very general, but just a quick overview there. So looking at this handout, if you'll flip to the family chart, we have Alan and Susan, who are a married couple. They have 3 children, David, Jennifer, and Richard. And Jennifer is the only child with 3 children of her own. There aren't spouses of the children listed here, but for purposes of what I'll be talking about, that's not important here. So let's say in this example that Alan is the one who passes away. The person who passes away will be called the decedent. It's just a formal name of the person who died. And let's also assume that Alan had a will. And a very common scenario that I see is that a spouse leaves everything in their will to their surviving spouse, and once the surviving spouse passes away, everything will go to their children equally. So let's say that, like I said, Alan passes away. Susan is the surviving spouse. He had a will, leaving everything to her, and Susan assumes, well, then I can just inherit everything because I have the will. He named me as executor. I can handle everything that way. And like I said before, unfortunately, that's not the case. If I were to represent Susan, if she were to come into my office, I would tell her to bring a few things. I would tell her to bring that will, specifically the original. The original is important because if there is no original, then there's the presumption that it was destroyed or lost. So a copy really isn't valuable in that case. And 2, because it is Connecticut statute that within 30 days of passing, whoever has that will needs to file it with the probate court within those 30 days of the person passing away. That is Connecticut law. Whether it's an attorney that's holding it in their office, whether it's the executor, whether it's a family member, whether it's a friend, whoever has it, it's their duty to file it with the probate court. So that the official document is there. So getting back to what I would tell Susan to bring in when she meets with me, even if it's very straightforward, even if, I think I already know where this is going, I would still have her bring that original will, a death certificate to prove that he is deceased and to have that date of death. I would also have her bring a list of what the assets are, what her husband owned at the time of his death, whether they were owned jointly with her, whether they were owned jointly with a child, or whether they were in his individual name. I would have her bring a list of what she has, and then also the value of those assets. So if it's a bank account, I would ask her to bring a bank statement reflecting that value as of the date of death. If it's a property, like a home, I would have her bring either an appraised value, or if she can get an assessed value of that property around the time of death. If there are any expenses that were outstanding that her husband had, any debts, specifically a funeral bill, if there's any legal fees, if he had outstanding bills that were due. So really just to get a comprehensive picture of what he owned and what was due in his name. So after she brings that information in, that is how I will determine what type of probate procedure is needed in the situation. And so we'll be talking about there are three different types of probate procedures in Connecticut. There's a tax purposes only procedure. There's a short estate or an affidavit in lieu of estate. And then there's the long estate or a formal probate. And there's different colloquial names for them, but in essence, those are the three types. So Maryanne is going to be talking about the formal, the long estate, so to speak, and I'll be talking about the tax purposes only and a short estate. So for a tax purposes only, that would be if Alan, in this situation, if he owned all of his assets either jointly, it could be jointly with his wife, jointly with a child, jointly with a friend. It could be owned multiple ways, but as long as it's not in his sole name, if he owns it jointly, or if the assets are held in trust, then those assets are not subject to probate. If everything in his name is owned that way, then we would be filing a tax purposes only estate. And I'm not going to go into exactly what documents need to be filed, but it's you submit the will, you submit the death certificate, you file a 706 NT, non-taxable, that's what that stands for. And it's to submit that will, it's to submit that will to probate and also to determine that there's no tax due, no estate tax due on it. A short estate, actually, let's flip to the family assets in this example because that will give a little bit clearer of a picture.
Excuse me, could you put the microphone a little bit closer?
Sure. Is this a little bit better? Sorry. I don't speak very loudly, so please let me know if you can't hear. So on this list of family assets, we have the West Hartford home and an old Lyme home. They have two properties. They each have a car. They have a joint brokerage account. Alan has a 401k in his sole name. They also have a joint bank account, and then they each have a life insurance policy. So based on this, that's another thing that I forgot to mention. So assets that are owned jointly or held in trust, or if they have a beneficiary designation, are not subject to probate. So in here, where I lost my spot here, Alan has the automobiles. Okay, Alan's 401k, that's what reminded me of that. So even though that's in his sole name, 401ks will have a beneficiary designation, so those are not subject to probate either. Same with the life insurance policies that are on here. Those will have a beneficiary designation, so those will not be subject to probate. However, we will see on this list that Alan and Susan both have their own cars. Now, Susan's we don't really care about because she's still living, but Alan has an automobile in his sole name. So that right there is a red flag. And we'll say, all right, well, now there's an asset that's owned in your sole name, so we're not looking at a tax purposes only estate. We're going to be looking at whether this is the short estate, the affidavit in lieu of estate, or the long estate, the formal probate. So now on this list, we'll see that Alan's automobile is $25,000. So that's important to know, and that's another reason why I ask to bring the values of the assets as of the date of death, because with the short estate, if there are any solely owned assets it'll be important to determine whether they are valued at below $40,000 or over $40,000. If all solely owned assets, if the sum of all those are below, the value is below $40,000, it'll be a short estate, the affidavit in lieu of estate. So, for example, in this example here with this chart, Alan's car is $25,000, and that's the only solely owned asset in his name. So therefore, a short estate is the type of estate that we would be filing. If he had a really nice sports car that he liked and it was $125,000, for example, we'd be doing a formal probate, even though it's only that one car that's in his sole name. Let's see here. It's also important to note with the West Hartford home and the old Lyme home, those are joint because the husband and wife own them with rights of survivorship. When a probate is opened, any real estate that you own, there is, I like to call it it's almost like an invisible lien that's placed on the home. And until you file a probate, whether it's the tax purposes only, the short estate, affidavit in lieu, or the formal probate, that lien remains on the home. And it's almost like a blanket that's on the home, and you cannot transfer it, you cannot sell it, the surviving spouse. They cannot do anything with that home until that lien is released from the home. And that lien gets released by opening up a probate or opening up or going through probate and paying the statutory probate fee that is assessed at the time of the filings. And that's based on a percentage of the gross value of the estate. So that also varies depending on the total assets. So let's see. And then of course, once you pay that probate fee, the court will issue a release of liens. It's a formal document from the court, and that gets recorded on the land records, and then there are no further probate encumbrances on the property. So for Alan and Susan in this example, there are two homes, so there will be two releases of liens that are filed, one with the West Hartford land records and one with the old Lyme records. And it's very important that both of those get filed. So I think that's just a pretty brief overview. I think that I'll turn it over to Maryanne, and I can certainly answer questions when it's time to answer questions about this.
Thank you, Kelly. Thank you. It's great. I just wanted to say before we continue, special thanks goes out to the West Hartford Public Library, especially Leah Farrell, who's here, who set this program up with the Probate Court. I'm really appreciative of that. And so that's wonderful. And then a special thanks to Jen Evans and her crew who are filming this. They're at Channel 5. So if you've missed something and you want to see it again, you can watch it when you watch the Channel 5 program. Kelly hit everything. The most important, I think, at the end, she talked about the probate fee. Probate fee is not a tax. It's not classified as a tax, but the probate court it has to assess a fee based on what the state of Connecticut tells the probate court to do, and they actually look at the assets that are reported in the tax return, and all of the assets, including those that are jointly held by Alan and Susan in this chart, will be listed in that tax return, and so probate fee will be assessed on all of the assets, even though they're not run through the probate process. I just wanted you to know that. All right, and without further ado, Maryanne Sharon.
So I'm going to talk about what is called a full estate, all right, assets over $40,000, but I just want to do a quick recap of what Kelly was talking about. If all of your assets are jointly owned, or you solely own them and you have a named beneficiary, you have to file what's called a tax purpose only TPO estate, all right? So that's that one. The second one is if your assets, remember Alan's car? He had a car that was solely owned. We have to file what's called a small estate or an affidavit in lieu. And there are specific forms for any assets that you own. So if you die owning jewelry that is solely owned, a car, a bank account, right? Anything that you have that's solely owned, small estate. I'm going to talk about what happens if the assets that you solely own, right, that don't have a beneficiary, that exceed $40,000, or you own real estate in your own name of any value. So even if the real estate is valued at $20,000, it doesn't matter. You still file a full estate. So that's why some people like to name beneficiaries on assets, because they get to avoid probate. But as the judge just said, on your TPO, when you file that 706, you must disclose the assets that you jointly owned or had as a beneficiary with someone. So the state of Connecticut still gets a fee, not a tax, but it's based on a tax return. All right? They get a little bite out of it, just so you know. Now, I want to make sure you understand, it doesn't matter if you have a will or if you don't have a will, right? So that the application is called a PC 200, Probate Court 200, and it is to open up an estate. If you have a will, it is called a testate estate. Why is it called that? Because the formal name of a will is called last will and testament. That's why it's called a testamentary estate. If you die without a will, you die intestate. As Kelly mentioned, if you die intestate, the state gets to decide how your assets are distributed. So for example, if you are married and you have no children, the state says, okay, your spouse can get it. If you are married and you and your spouse have children and they are the only children that you have, then your spouse gets $100,000 and he or she splits the rest 50-50 with the kids. That's not always the easy thing if you have a house, because you end up having to buy your kids out, for example, or you hope your children love you enough to let you stay there, right? So I mean, but it can be complicated depending on how these assets are held. If you have children from a prior marriage or a prior relationship, and you have children with your spouse, then everything is split 50-50. Also can be an uncomfortable situation. Think of all of those second marriages out there. They might love their stepmother when your father's alive, but they may not like her when she's gone, all right? So it is really important that if you don't like the way the state is going to determine and decide how your assets are going to be distributed, that you have a will. And in the next session, you're going to have attorneys who are going to be talking to you about estate planning. And today, we're really just talking about like what happens when you're dead. All right, so after you've either missed the opportunity or you have one. All right, so I mean, let's just be honest, right? That's what this is about. So anyways, a will does govern, right? So if you have a will, that's your wishes as to who you get your assets. And one of the questions that we get as practitioners is, all right, what if my will says, so remember in your little example here, you know, that 401k that Alan has? Let's pretend that in his will, he says, I want my 401k to go to my 3 kids. But his beneficiary is still his wife, Susan. So who gets it? Susan gets it, because the beneficiary designation, as you learned from Kelly, always supersedes, always trumps what's in your will. I do have, I don't know, maybe Kelly has this, maybe His Honor has this, but I have people who are anticipating divorce and they want to change all of their assets in their will because they don't want their spouse to get it. And I have to be the bearer of bad news and say, you don't get to change it. The will doesn't matter. If your spouse is your beneficiary, the spouse stays your beneficiary. Okay, so the will does not change that. Now, let's kind of go through the PC 200, the application to open up an estate. What's the first thing you need? You need a death certificate. Why? Because we need to prove that you're dead, right? The person, no, I'm serious. We need to make sure, is the person really dead? We need a death certificate. You have to do, if there is a will, you need the will. What did Kelly say? What is the value of an original will? It means everything. The legal presumption is that you intentionally destroyed that document if we cannot find your original will. There are exceptions. The court will have to have a full hearing. We'll have to have evidence to determine if it is appropriate to admit the copy of the will. But I have to tell you, it's a heavy burden. So make sure you keep your wills in a very safe place that is waterproof and fireproof, and your children know where to find them. So you need the will, You need the death certificate, and the application requires, remember, Susan came and visited Kelly. What did she have to bring? She had to bring what the assets were. She had to tell Kelly, this is where my 3 children live. You have to identify who your heirs are. You have to identify who your beneficiaries are if you have a will, right? So your beneficiaries may not be the same people as your heirs. You have to tell her, do you have a trust? Did Alan have a trust? Why is that important? Because you have to identify the trustee as someone who is a person of interest. What's the approximate value of the assets? Right? We talked about, we have this nice sheet right here. So this is your cheat sheet, but this was the information that Susan had to bring to Kelly. What are the assets? How are they held? Is there real estate? So there is a place on the application for real estate. Why? We just talked about it. Because the real estate has this, it's called an inchoate lien, and you don't get to sell the property or transfer it unless what? Unless you have probate court clearance, all right? So I think that's probably it. I think I worked you through the application. The next step, of course, is the heirs and everybody gets notice. People often ask, do you have to have a hearing? And the answer is maybe, sometimes, right? So, I mean, there is an opportunity for every person who is interested in the decedent's estate. The decedent is the person who died. There is an opportunity to request a hearing. So if someone requests a hearing, you get a hearing. If the judge has a question about your will, maybe it wasn't signed appropriately. Maybe there's a question about who the witnesses are. Maybe someone comes forward with a second will, right? Then you know you're gonna have a hearing. And if it's you don't have a will, then you are gonna have a hearing because the court needs to appoint someone to be the administrator, right? So you have an executor if you have a will, and you have an administrator if you don't have a will. So Kelly mentioned something that's really, really important. Just because you are named the executor in someone's will does not give you permission or authority to do anything until the court actually admits the will and actually approves you to be the executor. And we have all seen situations here where someone starts going rogue because they didn't go talk to Kelly, all right? They go rogue and they start going to the bank. They list the house for sale. They try selling the car. You can't do that until the court appoints you and you actually have a certificate of appointment. So I just want to make that clear that you do have to wait. So I think I told you that for hearings, you may have a hearing. The judge is very nice. Actually, most of the judges are nice. But they really want, it is, as His Honor said, a people's court. They want to make sure that the decedent's wishes are actually become manifest, right? That's what we're here for, and that's what we all try to do. But I do want to put a plug in for transparency with your children, because it can be a difficult conversation, but if you are not leaving something to all 3 of your kids, and I think Dawn is going to touch on this. You are, right? You are going to touch on it. That if you don't, then that's what creates animosity. That's what creates the resentment, right? And so that is going to create an atmosphere where the judge is going to have to get involved and figure out what's really going on. Did mom really love you more than he loved someone else? She loved someone else? Well, the answer might have nothing to do with it. Maybe mom just thought that, who's the daughter? What's her name?
Jennifer.
Jennifer needed the money more because she's the one with the kids, very expensive kids. I don't know, right? Or, so I'm just saying, please make sure your kids have an understanding. And if you don't want them to know, then just be prepared that there could be something on the back end. That's all. I mean, I'm not trying to get into anyone's business. So, however, you may have to hire us, and then we are in your business. So I just want to put that caveat out there. What is the role of the executor or the administrator? All right, I'm not going to sugarcoat this. It's really important. first of all, you have to answer to the court, you have to do what's in the best interest of the estate, and you have to understand that you do, in a way, represent the interests of the beneficiaries. You have to marshal the assets so that what goes to the beneficiaries goes to the beneficiaries. And so remember, Kelly was saying she wanted Susan to bring all of that information. So you have to open up an estate bank account. Sometimes the court will require you to be bonded. Do you understand what a bond is? A bond is an insurance policy to make sure you don't go to the casino with the estate money. Bond is an insurance policy to make sure that the money goes to the beneficiaries and is not somehow misused by the person who is the executor. Most wills waive bond, but when you are an administrator of an estate, the court is obligated to have you post bond, and the bond does have a premium that you pay annually, all right? Are the funeral expenses paid? I mean, the administrator, the executor is responsible for that. Is there a mortgage on the property? Well, you don't want the house to go into foreclosure. You gotta cut the lawn. You gotta make sure that there's heat in the winter time so that the pipes don't freeze. So identify who all the creditors are. Did the decedent have a tax return that's due, income tax, right, a 1040 that has to be filed? You're gonna talk to an accountant, you're gonna talk to your attorney. Is there an estate tax return, right? So people file 1040s, what do estates file? 1041s. Does an estate tax return have to be filed? And I cannot tell you how important it is to have very good records. I want you to maintain those records, and I want you to maintain them meticulously, because you must end up reporting to the court what came in and what went out. And you have to have an explanation, because one of those beneficiaries is going to say, what happened to this $10,000? And you better have an answer. So let's talk now about what forms you have to file. So the first thing, so you get appointed, 60 days after you're appointed, you have to file what's called an inventory. Kelly mentioned it. It is the date of death values of the decedent's assets. That's what goes on your inventory. That is a document that you sign and you file with the court. 150 days after you're appointed, you file what's called a list of claims. That is anyone who made a claim. So that could be the credit card company, that could be the leasing company for the car, it could be the caregiver, it could be the neighbor who lent your father money because he didn't have money. So anybody who has a claim, you have to identify who that is, and you have to say whether you paid them or you didn't pay them. All right, that's the list of claims. 6 months after the date that the decedent died is when you file that 706. All right, so if it's a non-taxable estate, right now, what is it, 13.9, 14.1 million, the big beautiful bill moves it up to 15 million, okay? But if you have a non-taxable estate, it is a 706 NT, non-taxable. If it's a taxable estate, you file what's called a 706/709. It's due 6 months from date of death. And that 706, as His Honor said, you must identify all of Alan's assets, no matter if he held them jointly with Susan or if he held them solely. So after that happens, you file your final accounting. Everything that came in, so if you get a refund on the health insurance policy, if there's interest income that comes in, dividends that come in, assets that you didn't know existed when you met with Kelly come in, you identify them on your final accounting, and you identify every expense that came out. The court reviews this. The court gives the beneficiaries the opportunity to ask questions and object. They get to request a hearing. So remember, do you have to have another hearing? Well, the answer is maybe, because the court gives a notice and it gives a certain period of time with which your beneficiaries or your persons of interest get to request a hearing. If there is no hearing requested, then the court can issue a decree if the court's own review believes that it is true and accurate. You are also swearing that it is true and accurate. I'm not saying you're going to go to federal prison or something, but it is something that you are swearing to. And in litigation, as Dawn knows and as I know, I have put people on the stand to ask questions about what's in that final accounting. And I will push them. And I'll be like, you swore to this. And they'll be, hopefully they crumble and I win. But I mean, right? But I mean, I'm just saying, you have to understand the value of it. Some people, some executors, they want to know, and I'll finish up shortly, want to know if they get fees, right? Like we always get asked, do I get a fee for my work? Well, if the will says you get a fee, you get a fee. If the will says my loving wife has to do it for free, then guess what? She doesn't get a fee. So the fee must be reasonable. The fee must be related to the work that you perform. You must be able to demonstrate that you actually did the work. So if your charges, you say, I want a fee of $10,000, His Honor has the right to say, what did you do for $10,000? The court also gets to ask, by the way, the attorneys, what did we do for $10,000? I mean, our fees also are subject to approval by probate court. So I'm not trying to just pick on the executor or the administrator, but the court has that level of review. I like to think that he picked us because he knows we're fair and reasonable, otherwise he wouldn't be asking us to be here, all right? Also, if there are expenses that you advanced, right? So maybe before you got to go to the bank and open up that bank account, you had to pay the mortgage. Well, you can reimburse yourself. There are circumstances when there are not enough assets to pay the expenses. That's called an insolvent estate. I'm not going to talk about that, but it is a separate procedure, and there is a hearing process that is dictated by statute with regard to how you make the payments, how you apportion those payments. Obviously, if there are claims, if there is, a will contest, if there is anything like that, then that's going to stretch the period of time within which the estate can be closed. And it can be expensive and time-consuming, and that's my handoff to Don.
Thank you, Maryanne. I have a new name, I guess, for this session. What happens to you when you're dead? So just two points, and then I'll turn it over to Don. You need to identify all the heirs. Why do you need to identify all the heirs when you file your petition with the court? Because they have a right to challenge the will. You may have done everything proper, your lawyer did a great job, you executed the will properly. That does not mean that someone can't challenge it. Anybody can come in who has a right to challenge the will. That doesn't mean they're going to prove that their challenge is correct, but they have a right to challenge it. So that's why they have to have notice. They have to have a fair opportunity to fight in court, and we give them that. The last thing is one thing that Maryanne emphasized is if you can make your loved ones familiar with what you're doing and why you're doing it, you'll save a lot of anxiety and a lot of problems, especially if it's children. And you'll spare the children from heartache. The children may be throwing stones at each other, saying, Mom didn't want that, Dad didn't want that, and Mom and Dad, maybe they did want that. And that's something that if you discuss it with them now, they might be upset with you now, they won't be upset with each other. And I think your goal generally is to have the family as a cohesive unit. You want them to go forward loving each other rather than upset with each other over assets. So with that, I'll turn it over to Don Neville. Don.
Good evening, everybody. I am going to be a downer for the night, so I'm also not going to be too close. I'm not a quiet guy, so I don't want to blow anybody's hair off. But I get involved. I don't prepare trust and estate documents. I don't do planning. I don't administer estates. I get hired when something has gone sideways, and there's a lot of things that you can do to stop things from going sideways. Sometimes you get a bad actor, and we'll talk about bad actors, but I can't stress enough the importance of getting planning. Trust and estate documents are serious legal documents. These are not things that you just put together quickly. They can have significant consequences from a family perspective, the economics, the emotional well-being of kids, everything that goes along with it. Take it seriously. I know it seems like a little bit of a plug, but going online and getting a will or a trust, if you don't understand what you're doing, you can have consequences, and the other part is people can take advantage of it. So talking about that part is I'll talk about a power of attorney. So a power of attorney is a document, I'm sure a lot of people are familiar with it, you can sign where you designate somebody to act as your agent. And technically speaking, that person should only be doing exactly what you tell them to do, okay? But I should also, drink plenty of water and eat all my fiber, and I don't do that either. So what happens is they're broad and sweeping powers. I mean, you are effectively allowing somebody to control or at least take advantage of every single economic aspect of your life. Your banking, they can transfer real estate, they can do virtually anything. They can change beneficiary designations, they can do everything. And so the story I tell is the worst one I was involved with, but there were two sisters, elderly, lived here in West Hartford, had a grandnephew, gave him a power of attorney, and when I got involved, he had transferred $2 million. And that included, 2 pieces of property, a condo, bought himself a condo, transferred retirement accounts. When I got involved, we were able to get back, 1.2, 1.3, 700,000 was just gone. I mean, and it wasn't gone like I think he put it in the Cayman Islands. He just spent it on things, and that money is just gone. And the devastation for the sisters once they found out that this grandnephew did it. And it was all because they granted him a power of attorney because I can't remember what it was. They were going on a trip and they wanted him to be able to, do the banking or open the mail. But you really need to be very careful. And I know everybody's like, oh, I trust him completely. All right, I mean, the famous last words, but, monitor your stuff if you're gonna get a power of attorney and make sure that it's done correctly. Because on the form, there are things you can restrict on a power of attorney. So you have to, I forget now if they're long or they're short, but you can limit what people do. So if you want it to be just for banking because you're going abroad or something like that, you can make it limited. If you're gonna give somebody a broad one, just go in eyes wide open. So then the other place that I do get involved in power of attorney issues, those are gonna come up again in a minute. So I get involved in a lot of will cases. And so we have what are called will contests. And they said that the heirs can come in and dispute the will. And they're entitled to do that. And there's usually 3 ways that a will gets contested. One is it wasn't done right. That is incredibly rare. I've been doing it 20 plus years. I've never seen one of those succeed. The other one is incompetence, where mom or dad is in a rehabilitation facility, they're really struggling, they're cognitively limited, somebody goes in, gets a will signed, and then mom or dad pass away shortly thereafter, and there's a fight about whether or not mom and dad really understood what it was that they signed. And then what goes hand in hand with that is what's called undue influence, which is maybe they weren't legally incompetent, because the competence level that you have to have, testamentary capacity is what it's called, is very low. I mean, it's lower than to sign a contract. So it's really just the basics that you need to understand. So sometimes people are above that, but they're in the house. They've been, the daughter in this case, Jennifer has alienated mom and dad from the brothers, and she's just relentlessly every day saying, I want you to sign this. And that's where the fights come in. They were talking about having, transparency with your family. And I get contacted very frequently by people where there's a will that's disproportionate in the caller's eyes. And usually there's some sort of reason for it. So the example I came up with is that, Jennifer got divorced, so she's got 3 kids. She moves back home with mom and dad, and they support her and her kids for 2 to 3 years. But then mom takes a fall, dad starts to decline a little bit, and all of a sudden Jennifer now is really providing caregiver. She's driving them to appointments, she's making dinner, she's doing all that. She does that for 10 or 15 years. And mom and dad decide, you know what? One brother's in New York City, he's okay. The other brother is out in California, I think he's okay. I'm gonna leave, I forget what number I picked, 80% of the estate to Jennifer and 10% to each of the boys. Maybe that makes perfect sense, and maybe it's perfectly reasonable, but they don't tell the boys. And then they pass away, because usually it's the last one before they find out, because they have what are called sweetheart wills, where everything goes to the spouse if they're alive. And then all of a sudden, they find out that mom and dad have picked the favorite daughter that they always loved more. And like that's, I mean, I joke sometimes that it's like I didn't get the Huffy bike. Like it brings up all of that kind of stuff for people. And they're, unfortunately, a lot of times what they believe is you were living in mom and dad's house for 15 years. You were constantly harassing them about this. That's why they did this, not because they wanted to. And it just, it destroys the family. And so that's more a pitch for the transparency, because if they had had that discussion, maybe the boys would have been upset, but at least they would have heard it from mom and dad's mouth. And that makes a big difference for how those things get done. And will contests are expensive. It's medical evidence. It's for all intents and purposes exactly what you think of for a trial. So even, it's in probate court, but we do discovery, we do depositions, we subpoena records, we bring in witnesses. You're talking, $50,000, $60,000 on some of these estates. So I can't stress enough the importance of transparency if you're going to change something. They had talked about it, sometimes an administrator gets appointed because there is no will. Sometimes there's a fight about who should be the administrator. The older brother thinks it should be him, the daughter who's in Connecticut believes it should be her. Those fights happen. I try to tell people don't have that fight. Let's just get somebody appointed, but those can happen. The other problem occurs mostly in trusts. And so what happens is mom and dad, this usually comes to me in one of two ways. Either, in this case, the boys had no idea that there was a trust. So mom and dad pass away, and they say, according to the list, there's $1.775 million. And Jennifer gets appointed, she files her beautiful inventory, and it's $6,000. And the boys are like, where's the 1.7 million? And she was like, oh, mom and dad created a trust 10 years ago and put everything into the trust. And I'm the trustee, and me and my kids get most of the beneficiary we get income for life, right? And so now all of a sudden the same problem occurs in the trust. And again, maybe mom and dad did do that, but they needed to have had that discussion with them so that they knew it. Otherwise, again, it becomes this push and pull of you were trying to make sure that you got the money, and I didn't get the money. Then I had a brilliant one and I've forgotten it, but. Oh, so here's the other one. All right, that's sorry. I remember now. My brilliant recollection. So in a trust, as the settlor, as the person who creates the trust, you're entitled to determine not just who the trustee is, but also the scope of the trustee's authority. So that means they can have, any of a range of mandatory, you gotta give the boy, you gotta give the two brothers $5,000 a year. You gotta give my grandkids $6,000, all the way to sole and absolute discretion, which effectively means I can do whatever I want, whenever I want, under any set of circumstances. And what mom and dad may have done was vest discretion with Jennifer. And now, whether mom and dad meant it or not, Jennifer gets to decide where the corpus of the money goes. She can choose to not give her brothers anything. She can choose to just give it to just herself. That's a little harder, but often what they do is they give it to the grandkids. Because to give yourself money, it looks odd, but you give it to the grandkids. And so, that's it comes into this sense of not being fair. I'm dancing between the ideas of Jennifer being a bad actor. Certainly she could be. Maybe she concocted all of this in a Machiavellian effort to sort of take over the family. But she may also just really legitimately believe that that's what mom and dad wanted. They wanted me to have this. If you went to somebody that knows what they're doing, both of whom are here, they would say to you, you want to put some restrictions on this. If you really want to make sure that she's giving 5 Gs a year or paying into a 529 or whatever it is she has to do, put it in there. But if you leave it to discretion, moods change, things change, dynamics change, and it's a recipe for disaster. So the last topic is, a plug for being careful about second marriages. I can't speak for whether or not love but the second marriages from a probate perspective are almost always, I shouldn't say. So here's the problem. I only get involved in things that go south, right? So to me, it's the second marriage is always a problem because that's what I see. So maybe it's not always a problem, but certainly I can tell you that the emotions, the chili runs hot when it comes to a second marriage, and it's hot for everybody. I don't want to make it sound like it's just the kids. Certainly the second wife, there's a history everywhere, and they can be very, very delicate. And so again, you really want to go see somebody so you can have those, and even more importantly, have transparency. As an aside, the funniest story I ever heard was a woman. She was the matriarch. She had this huge family. Dad passed away, and she just called everybody in, kids, grandkids. She may even have called like nephews in, and she gave them all stickers. And she's like, I want you to go around the house, and I want you to put stickers on any of my stuff that you want when I die. And if there's a fight, I'm deciding it now. And I thought it was like, but to me, that's a great example of the transparency. She didn't want to have any arguments about heirlooms, and I made this for you when I was 9, or whatever the story was. The last place that I get involved a lot are accountings. And Maryanne had talked about it, and what it basically means is that you, the fiduciary, has to answer for money in, money out. And that comes up in the context of decedents' estates, so fiduciaries, executors. It's a little less common with executors because you know from the beginning sort of what's there and what is there at the end. It comes up a lot with trustees. I get a lot of times where the beneficiaries are saying, I don't know what's going on with the money. I haven't seen an accounting. I haven't seen a bank statement. I haven't seen a report in X amount of years. They're under the new revised statute and the new act, they're supposed to give an accounting. Very often they don't. You have to go to court, ask Judge Egan to order them to do it. They do it. It's an expensive, drawn-out process. And the worst thing that can happen is to find out that money is missing. And sometimes it's as little as 10 grand, but I've seen times where it's hundreds of thousands of dollars are missing. And often it's leaks sort of over the years, $1,000 here, $2,500 there, that kind of thing. And again, it can cause so many problems relative to the family. The last place I would say that it comes up is in POAs. So if somebody is a power of attorney, if a family member believes that the mom or dad or whomever has been taken advantage of by somebody that's a power of attorney, they can also petition the probate court. It's a little more complicated, but roughly speaking, for an accounting to find out what's happened to the money and what they've done. And that generally will follow the same process. I have had cases in which I file I contest the accounting in the decedent estate. I petition for an accounting of the trust that was purportedly created, and I also have to do a power of attorney accounting because they've created this trust and estate plan really without any guidance, so it's sort of haphazard, and now we have to unpack everything that's gone on for however long it takes. And all of this stuff is expensive, and it can be avoided, not by seeing me. It can be avoided by seeing a practitioner in this area. Kelly, Maryanne, I can't stress enough. Everybody that asks me, because they know I do only litigation, they say, what's the best bet? I say, first of all, go see a qualified professional. And what I also tell people is prepare a death file. So I have one. I want to tell whoever it is that's going to be in charge, tell them where the will is, what your computer password is, what your phone password is, where your banks are, where your life insurance is, your retirement accounts, because I haven't dealt with this myself, but I'm sure both ladies have, that they don't know. They don't know where any of this stuff is because mom and dad keep this stuff so secret that then they try to figure it out. They're like, I don't know where mom and dad bank. So that's it. And then a plug for the idea that it goes to extended families when there's a probate fight. So even though maybe your mom and dad's brothers and sisters, so the uncles and the aunts and uncles, they weren't named in the will, they didn't have any expectation of it, they're gonna know what's going on. And it's going to cause problems beyond just the nuclear family. It's going to cause it in the extended family, friends. Everybody's going to know what's going on, whether you want them to or not. Not because of the court, but because everybody talks. And so it's just devastating like that. So, one, get help from a qualified attorney. 2, think carefully about the decisions that you make. And 3, be open with your family about whatever you decide. And I hope with those things, you never have to come see me. So.
Thank you, Don. I really appreciate that. Just 2 points. One, Don talked a little bit about trust. Very good estate planning tool. It's something that can help with litigation. Don could probably talk about that as well. That doesn't mean that he won't attack a trust, but they are a tool that both Kelly Ambrosio or Maryanne Sharon could help you with, and those are something to be considered. The other was the importance of the executor or the administrator. I'm going to deviate just a little bit. It is important if you're named as an executor of an estate I always tell a client to maintain that position if you can do it, because you might have to defend against a gentleman like Don, and you want to be able to be in control of the estate, and the attorney representing you, it could be Kelly or Maryanne, will want you to be in control of the money, the purse strings, because your lawyer can be paid. Don is being paid by a beneficiary who is upset with the way things are being handled. So there is some importance with being an executor of an estate. But his point is well taken. You don't want to be fighting over things that you're not worried about. If your family isn't going to be fighting over assets, then the appointment of the executor or the administrator really doesn't matter. So they were all excellent. They stayed right on time. We have about a half an hour for questions and answers. So I want to open it up for that, and then I'll let any of the individuals that are here field those. Yes, ma'am.
Hi. Just to clarify, so.
Hold on a second.
Give you a
Do you
speaker.
want us to do the microphones to the questions?
That would be great.
That one she's.
Oh. I know. I was trying to be helpful.
Thank you. Thank you, Leah.
So just to clarify, someone dies and you've been named executor, but you're not approved. Are you okay to go ahead and do the funeral? Do you pay those costs out of your own pocket? How does that occur?
Who'd like to take that? Maryanne?
I'll take it. So yeah, so you have someone in your family who passed away. If they didn't prepay for their funeral, the funeral director would be very happy to take your money. And then after you're appointed, assuming that there are assets, a bank account, you can reimburse yourself, and the court has to approve that expense.
And if there are no assets, can you bill, like maybe there's a sale of a property down the road, but no bank assets currently?
Yeah, so oftentimes there are no liquid assets, and the only liquid assets come from the proceeds of the sale of the real estate.
Mm-hmm.
And then we would be paying all of the expenses out of that, right? So remember, the executor has to marshal the assets, take control over that bank account, and so the proceeds get deposited into the estate bank account, and then you are responsible to pay probate fees, the other expenses, the funeral, and things like that. And so, yeah. Sure.
To just follow up on that, sometimes a loan has to be made by an individual to the estate. They do not have to make that loan, but it's treated as a loan. So if the funeral costs were $10,000, they might advance that money to the estate, and then they seek that repayment once the executor or the administrator is appointed, and they should be repaid at that time. But if they don't have money to loan, then you have to talk to the attorneys about how to handle it after that. And the attorney's phone numbers are on those sheets, those colorful sheets. You can call them after this and ask them any question you'd like. I know they're ready for those questions.
Is my cell phone on here?
Yes, sir.
One of the questions is that when I die, I have 3 kids, and I am not going to give equal to each, because one kid has about $10 million. Other kid is not married and has no children. And then I have a daughter who has children. And I have decided that I'm going to make will, but I'm going to make sure that they all sign as a witnesses that they have all agreed that the daughter is going to get 80%, the rich child gets 5%, and the guy who is not married get 10%. And they all sign that they now understand that the division which is made is based on the equity that we all agree. Then I asked that.
You're putting me out of business. What are you doing?
What kind of fight there will be afterwards?
So the question is what?
Everybody has agreed and signed.
So do you need to have them sign off on it?
No, I'm making sure they sign.
So are you asking whether that would
What
be,
kind of dispute there will be afterwards?
are you asking whether that would be helpful if there was a lawsuit
Yeah,
brought after?
yeah.
We'll ask Attorney Neville about that, but I'm gonna tell you, you just announced.
I was saying the same thing. Just have your
announced to
children
the
watch
public,
this.
And it's on film.
Exactly.
So, but Attorney Neville,
I said, I wouldn't, if one of them came to me, I wouldn't take the case, based upon what you just said. That would be hard for them to fight. So,
If they all sign.
yeah, well, they may say they didn't sign, so
No.
get it
we
notarized
have
and
signed
everything like
by
that.
notarized,
I know, I'm just kidding,
drawing
but
up
yes,
everything.
yes.
so Attorney Neville, would you use the film from tonight?
I would use the film. Yeah.
So, yes, sir.
Yeah, I just want to bring up that I went through this last year when my wife died.
So you want to?
Yes, I did, and I was very proud of myself that we did so well that if we qualified for a small estate. There are two gaps in the law right now. Because it's a small estate, there is no named executor,
That's true.
okay, because it doesn't go through probate.
Correct.
That means I could not get access to my wife's medical records when there were some questions about the care, or not really, but the kids had questions about the care. Medical power of attorney, all that passes away and everything gets locked up.
Right.
And only an executor or a court-appointed representative, which means you gotta go through probate court, can get access to those records. And also, in terms of records that you feel you have access to, it's a little unclear. When M&T Bank took over for People's Bank, M&T Bank couldn't find the beneficiary papers designating me as her IRA beneficiary. And they claimed that it took us 6 months sending them back over and over again to have them find it. I knew it was there because I was the one that helped, so we set it up. But the law there was no, so far, unless they've changed it this year, the legislature in Connecticut have not addressed those two questions. In many states, the next of kin has access to those things because it's been legislated. But when I went to the probate court, they said, get a law passed, because I can't help you. I just want to be clear about that.
Okay, so I guess Attorney Sharon, do you want to just address
Yeah, so first of all,
the lack of an
as
executive?
attorney, thank you. The documents that I prepared do allow family members, whoever has power of attorney for medical records, to obtain them 6 months after someone passes. So you can, in the POA documents, depending on how they are drafted, still allow you to get medical records. The other piece, of course, is that you are correct. In a small estate, you're not admitting a will. Okay, all right, so you are correct. Oftentimes what we do is we open up a full estate. So if I know that you want medical records, I file the PC 200, I get you appointed, you get your medical records, and then there's a process whereby you can convert it to a small estate. It's very easy. Most attorneys do it. as a matter of course, because we are looking for assets. Banks are always a problem, and frankly, no offense to anybody here who is at M&T, but they suck, and that, I mean, honestly, and that transition was horrible for them, and there is nothing that the probate court or we as attorneys could do because they lost your designation forms, all right? But you can open up as a full estate. It's not very hard. Your will her will would have gotten admitted, you get appointed, you get your records, and then we convert it. So there is a special application that is on our nose, and we are able to convert it to a small estate. You pay the fee off of the 706 NT, and you're done.
Attorney Neville.
I can't remember, do you have to have a state open to get a limited examiner appointed?
It's a separate application.
Right, so even if you don't, so even if they had they still could have gotten a limited examiner appointed.
Correct.
Yes.
So what you can do is
Yep.
petition for somebody to do solely what you're talking about, which is to
Obtain
get
medicals.
medical records. Sometimes financial, but almost always, or maybe mostly.
I was told you have to report that you're questioning the treatment, and this may be for legal purposes. We just wanted to get access to the record from the portable heart monitor that what she had on her when she died. We wanted to know what exactly happened during those 9 days she was carrying.
Right.
Yeah, carrying that, and we could not get it.
Yeah, but that's how you would do it. So there's two ways with probate court that you can do that.
All right, yes, ma'am.
I actually have two questions, one from Maryanne and one from Kelly when they were talking. Kelly, first of all, if I actually know a family, the parents refused to make a will, there's 2 children in it, not mine, but somebody I know, and they're complaining to me all the time about that. There's two siblings from that, so they have to go to court. How does the court determine who best would get appointed to take charge of that in that situation? So that's the first question.
Sure. Quick. Thank you. Yeah, so in terms of appointing an administrator, when there's no will, so there's no executor, someone can petition the court. So oftentimes it's a close family member. But if there are people who are fighting over it, and say, in your example, say one of the children petitions and says, oh, I'm the daughter and I'm gonna probate my parents' estate, and then the other sibling comes in and says, no, I wanna do it, that's when it gets a little hairy, and you might have to have a hearing about it. And then in that case, a judge would determine who it would need to be. But in those, basically to answer your question, a petition would need to be filed to determine who would do that.
And the court, if the court has 2 people that are going to be equal beneficiaries and there's fighting, then the court may appoint a neutral.
Yep.
They may appoint an attorney, somebody who will dispose of the fighting and just say, pox on both your houses. We're gonna appoint someone who's gonna do this, and then they're gonna divide up the assets and distribute them to the 2 beneficiaries equally. So.
Question about the executor fee that you can collect. If it's not stated in the will, it doesn't say whether you should or shouldn't get it. Does the state of Connecticut pay you one if you request it?
So you can
submit it as part of your final accounting, a request for your fee.
And you would have to demonstrate, can anyone hear me? You can demonstrate that you're entitled to that fee. And like I said, the standard is it fair and reasonable? What work did you do? Is it related to that? And then the court can determine if the fee that you requested is reasonable. And I also want you to know, you do have to issue yourself a 1099.
And one other thing, you said if the state of Connecticut pay you?
No.
It's not stated one way or the other, but you request.
Yeah, thank you.
As executor.
Yeah, no, it's the line about will the state of Connecticut pay you? So it's not the state of Connecticut, it's the estate. So if the estate has no money,
Right.
you
You
get
don't
nothing.
collect.
Right.
Okay, Yep.
Yes.
Yes, ma'am.
I'm coming.
If an asset is out of the state of Connecticut, do I then have to file something in New York? Like a co-op.
So the asset, like a co-op, is owned in New York by the decedent, the person who died?
Connecticut, who
Okay.
lives in Connecticut.
Okay, I'll let one of the lawyers field it. I know it's, Kelly, would you like to?
So do you have to deal with ancillary estates?
Sometimes, I mean, so the first thing to determine is where the person is domiciled, and domicile means where they are a legal resident, or say, for example, if someone lives half the year in Connecticut, half the year in another state, where are they spending 6 months in a day? Where are they spending more of their time? That's where they're domiciled, and that's where a probate will need to be filed. So say it's already determined that they're domiciled in Connecticut, but then they have outside assets, whether it's property or in this case a co-op. If a probate does need to be filed, sorry, this is scratching. And you're listing the assets on one of the forms, then there is a spot to list out-of-state assets or out-of-state real estate. And so I have never dealt with a co-op. I don't know if you want to.
Yeah. It's better
Attorney
if you
Sharon?
have a trust. In the absence of a trust, you do have
to do what's called an ancillary probate in New York for the co-op. Kelly is correct. If you are a Connecticut resident, you do disclose it on the 706, and you will be treated as an asset for purposes of the 706 fee, but you are going to have to probate that separately in New York.
So an ancillary estate is like a satellite estate that you set up in the other jurisdiction. And they require what's called an exemplified copy of the will. And that's a fancy name for a copy of the will that's certified by this probate court. Because there's only one true will, as they spoke about, one original will that's filed with this court, say in West Hartford. And then we sign off and say, we have the original court in New York. Here's a copy of the original, but you can rest assured we have the original. And then they start the process in New York. But co-ops they can be tricky, so you have to have a lawyer in New York help you with that, and then the lawyer in Connecticut as well, because there's tax issues, et cetera. So, any other questions? Yes, sir, in the back corner.
What advice might you have when it's clear that your executors are all kids who live out of state? Are there things to be done ahead of time to make it easier for them? Can hearings with the probate court be done by Zoom? If you could comment on that, both for executor and power of attorney.
So with regard to hearings by Zoom, yes, we do hearings by Zoom, or we do hearings on the, we allow people to attend by phone. Occasionally they have to be there if testimony is required. It's better to have a person here, I think. Attorney Neville would agree. Cross-examination by Zoom is very difficult, and it's not fair. But for the most part, yes, we would allow people to attend hearings by phone if they're out of state. What was your other question, sir?
Well, are there other aspects of executors being out of state?
So they do have to file a form agreeing that the probate court is the agent for service.
Right.
All right, so it's not unusual, right? Our children have their own lives and they move out of state. And because of COVID now, the courts are completely set up for remote hearings for their participation. And the court does allow for what's called e-signed documents, so it's much, much easier to have an out-of-state fiduciary. But if you are out of state and there is litigation or service of process or something, each of the out-of-state executors must sign a specific document allowing the probate court judge to be the agent for service of process. And that's really the only other complication, I think, when you have an out-of-state, a child who's out, hopefully the child's responsible, right? And is willing to have all the mail transferred to him or her, and can have someone maintain the assets here. So that makes it a little difficult, but if you have someone who can mow the lawn, you have someone who can take care of all those things, then you're gonna be fine.
The agent for service of process is someone who can receive a lawsuit. So Attorney Neville files a lawsuit, he can serve it on the judge who is named as the agent for cert, and then the court will farm it out to the executor who's in the other state. And that's to protect the people of our state. So that they're not saying, okay, where is this executor? I'm a creditor, the decedent owed me money, I gotta find him. And instead of having to find that person in California, they just serve the judge. And Attorney Neville may want to comment on that. It's, I'm sure, a lot easier than serving the person in California.
It doesn't really matter to me at that point, to be honest with you. I mean, because they're here, they're conducting business here, so I can find them and get them done. I think it's more for convenience for the court, because the court has to send them notices and the creditor, I do represent creditors, you have to serve the executor with a letter, you want to make sure you know where you're sending it, sometimes they can dance and play games, and then I could just serve Judge Egan, so.
What was the name of that again?
Agent for service of process.
Agent for service?
Of process. Process is somebody serving a lawsuit or serving legal records or documents on it.
Time for one more question?
Time for one more question.
Who's it gonna be? You can still talk with them afterwards, so don't worry about it.
I'm looking at page 5 of your blue handout, and the second paragraph suggests that there's no need for a firearms trust in Connecticut, that an executor can sell to somebody who is licensed, permitted to own firearms, the decedent's firearms. Is that what you intended by that paragraph?
I'll let Attorney Sharon answer. Firearms trust.
Yeah, thanks. So, I just wondered if the feds
Gives me the last question, the specific language of a document I did not prepare. All right, so firearms is, in Connecticut, Connecticut is, probably everyone here knows, has one of the tightest firearm controls and firearm laws, all right? So the fiduciary can take possession of firearms, transfer them, so whenever a client comes to me, one of the questions that I always ask is, do you have firearms? Because we want to transfer them to somebody who has a license to carry and who license can cross state lines. Because it is a federal offense if you take a firearm and you're not registered for that firearm and you cross the state lines, that is federal prison, by the way. So what happens is that we want to transfer it to somebody who can carry. And here it says firearms may be sold. I think this is second full paragraph on that page. So she's referring to a line that says firearms may be sold or transferred only to persons who are legally eligible to receive them. That is absolutely true in Connecticut.
Cool, good.
Yeah.
All right. So I want to thank Leah Farrell. I want to thank you all for coming. I appreciate it. I would like you to just give a round of applause for Kelly Ambrosio. So it's Kelly Ambrosio, Maryanne Sharon, and Don Neville. So thank you very much.
Before you leave, there are evaluations on the back counter. If you would like taking the time to fill that out, and then go ahead.
One last thing. The next part of this 4-part series is on October 7th at same time, same place, 6 to 7:30 here. And I really appreciate you being here. Thank you very much. I look forward to seeing you again. Have a great night.
Thank you. Katie Sargent.
Hi, Katie.